Hi, welcome everyone. My name is Pratibha, and today me and my friend Mohammed are going to explore two crucial legal framework in business law, that is contract law and negligence. These laws are very fundamental in ensuring fair and lawful business practices. So let's move to the next slide. Imagine waking up to the world without no laws, where chaos is the new normal, no rules, no order, chaos and confusion. This statement signifies the importance of law. Law is there to maintain order and proper functioning of the society. In the business world, deals aren't just made with handshakes, they are governed by specific laws. This presentation focuses on two crucial areas of business, that is, contract law and the law of negligence, and we'll also look at the impacts of this law in shaping business practices in Australia, influencing how businesses operate, manage risks, and handle liabilities. And we'll provide some real life examples of breaches and implication of those breaches. And at last, the presentation will suggest practical tips for managing risks and compliance. So what is a contract? Contract are part of our everyday lives, often without us even realizing it. When we rent an apartment, buy a car, subscribe to a streaming service, buying groceries, starting a new job, we are entering into contracts every day. A contract is a legally binding agreement between two or more parties that is enforceable by law. Here are some key elements of a valid contract. That is offer, which is the initial proposal by one party, and then comes acceptance, which is the agreement to the offer's terms, and consideration, that is something of a value that is exchanged, and then mutual consent, which is both parties must agree to the terms of the contracts, and then comes legal purpose. The contract must be for a lawful purpose, it cannot be for anything illegal. And then comes the capacity, which is the parties must have the legal ability to enter into the contract. Contracts can be communicated in writing, orally, or by both means. Contract law in context of business. Contract law in context of business ensures that agreements between two parties, the two business parties or two parties, are legally binding and legally enforceable. It's a set of rules that governs the creation, execution, and enforcement of agreement between two parties. It provides a legal framework that ensures agreements are legally binding and enforceable. Predictability, it provides certainty and clarity in business transaction. Dispute resolution, it offers mechanism for resolving conflicts and breaches. So what is a breach of contract? A breach of contract is a failure to fulfill any of the agreed upon terms and conditions of a binding contract. And there are impacts of breach of contract that can be financial losses, that is, the non-breaching party may suffer monetary damages. It can be operational disruption, like it can cause delays and interruption in business operation. There might be reputational damage, like it can harm a business's reputation and relationships. There might be legal consequences. They may face lawsuits and be required to provide remedies. So here we look at one of the example of contract breach. So this is a case, Transport Workers Union of Australia versus Qantas Airways. So during the COVID-19 pandemic, Qantas decided to outsource over 2,000 of its ground staff to save money, and this move was challenged in court and it was ruled illegal because it was seen as an attempt to prevent workers from exercising their rights to collective bargaining and industrial action. So, as a result, Qantas was ordered to pay significant compensation to its affected employees. So, this kind of breach will cause significant impact on Qantas' corporate image. Here we'll look at another example of contract law breach, that is Cessnock City Council versus another party. The another party is Kutisharp. What happened is in 2007, Cessnock City Council agreed to grant a 30-year lease to the corporation Kutisar for developing part of a proposed airport, but the council failed to register the plan of subdivision by the agreed deadline, which breached the contract. And what happened is the corporation suffered financial losses after investing in constructing a hangar based on the lease. So the decision of the High Court was High Court upheld that Kutisar was entitled to recover 3.7 million in damages for the expenditure incurred in reliance of the contract. And the implication of such cases is that you can have significant financial losses in case of breach of contract, and there is also reputational damage.
Thank you, Pratibha. In these slides, I'm going to talk about law of negligence in business. So it usually refers to failure to exercise the level of care that a reasonable person would in similar circumstances. So law of negligence usually consists of four key elements, which is duty of care. So every business has the responsibility to act in a way that it does not cause harm to others. Second one is breach of duty. So usually a breach occurs when the business fails to meet the standard of care expected, such as not following protocols. The third element is causation. So there must be a direct link between the breach of duty and the harm caused. This means proving that the negligence directly resulted in damage. Number four elements is damages. So the plaintiff must show that they suffered actual harm or loss due to negligence, which can be physical, financial, or emotional. In these slides, I'm going to talk about impact of negligence in business. A company can suffer significant financial losses due to negligence, which can include legal cost and compensation payments. They can also suffer from reputational damages, which can lead to lose a lot of customer trust and potential business opportunities. They can also suffer from operational disruptions. So they need to divert their resources to handle legal matters and implement necessary changes. So in these slides, I'm going to talk about legal consequences. So for civil liability, business may be required to compensate the injured party for any damages they have caused. For criminal penalties, in cases of gross negligence, criminal charges may be brought against the business or its executive members. For regulatory actions, regulatory bodies may impose fines, sanctions, or give other penalties. For personal liability, directors and officers may be held personally liable for any kinds of negligence. Now I'm going to give an example of how a negligence can cause serious damages to a company. It happened to Vision Australia back in 2015. So there's an employee named Mr. Elisha. He was involved in an incident during his work trip at a hotel. He complained that there was too much noises, but the company didn't listen to him, and they said that he was too much aggressive. Then they terminated his contract. But they didn't actually follow any proper disciplinary procedures before terminating his contract. So this termination of contract actually caused him serious psychiatric disorder, and it's actually profoundly impact his ability to work and his overall well-being. Then the High Court ruled in favor of Mr. Elisha and awarded him with over $1.4 million in damages. In these slides, I'm going to talk about some strategies for managing risk in contract law and the law of negligence. So for risk assessment, before drafting any sort of contracts, identify potential issues and address them proactively. For standardized templates, always have to use clear and ambiguous language to avoid misunderstandings. And company needs to constantly conduct regular audits to ensure compliance and address any issues as early as possible. For training, companies to provide regular training to its employees for following safety and compliance to prevent negligence. For documentations, they always have to keep records of any procedures and incidents to defend any against from any claims. For insurance, they always have to obtain professional insurance to cover potential negligence claims. Thank you. Please let us know if you have any questions.